Welcome. Court orders forfeiture of GBM property to the state. On February 25, 2026, the Lusaka High Court delivered a significant ruling in a prolonged legal dispute involving former Defense Minister Geoffrey Bwalya Mwamba, commonly known as GBM, ordering the forfeiture of his property to the state. Judicial ruling and case outcome. The court determined that the property in question, a residential structure along Lusaka Road in Lusaka, was subject to forfeiture under Zambia's asset recovery laws. After a detailed assessment of how the property was acquired, the judge concluded that the legal requirements for forfeiture had been met, prompting the transfer of ownership to government authorities. Legal submissions presented in court indicated that the evidence surrounding the property's acquisition and financial documentation failed to satisfy statutory thresholds for lawful ownership. Deputy authorities involved in the prosecution argued that the matter fell squarely within the scope of Zambia's asset forfeiture legislation, designed to recover assets deemed to be proceeds of unlawful conduct. With the judgment now in effect, state agencies are expected to complete administrative procedures to formalize the transfer and determine the future use or management of the asset. Public and political reaction. Given GBM's status as a well-known political figure, reactions have been mixed. Supporters and critics alike have expressed views along political lines, with some questioning the timing, and others emphasizing the importance of enforcing the rule of law. Despite this, officials have consistently stated that the decision reflects legal deliberations and not political motivation. Context: GBM's legal history. This forfeiture comes in the wake of earlier legal disputes involving GBM's conduct and financial dealings. In October 2024, he was convicted on several charges, including conflict of interest, possession of property reasonably suspected to be proceeds of crime, and money laundering, resulting in a sentence of 5 years imprisonment. Following those convictions, the courts also ordered that he repay substantial amounts to the state treasury, including $899,970 and $20 million, as part of alternative orders designed to claw back alleged proceeds of crime. Broader trend in asset recovery. The forfeiture order against GBM forms part of a broader pattern of asset recovery cases in Zambia, where courts have increasingly applied the Forfeiture of Proceeds of Crime Act to recover property and funds linked to unexplained wealth or criminal conduct. For example, in February 2026, the High Court ordered the forfeiture of assets worth over ZMW 24 million belonging to Dalitso Lungu, the son of a former president, after finding there were proceeds of crime. Previously, other high-value properties, including large farms and commercial holdings, have been ordered forfeited in cases involving members of prominent families and business figures who could not satisfactorily explain the lawful origin of their assets. These cases demonstrated judicial willingness to scrutinize the ownership of high-value property when legitimate acquisition cannot be demonstrated, and reflect Zambia's growing emphasis on accountability and financial integrity. Legal process and next steps. For GBM's property, enforcement of the forfeiture order now shifts to administrative authorities. These bodies are tasked with valuing, managing, or disposing of the forfeited property in accordance with the law, ensuring that the state benefits from assets previously held under questionable circumstances. While GBM's legal team may explore grounds for appeal, the current ruling marks a pivotal moment in the case's trajectory and underscores the role of the courts in adjudicating disputes over property and alleged illicit wealth. More details are expected as both security officials and the PF issue official statements regarding the raid. Thanks for watching. For more content like this, please comment, like, and subscribe to the channel. One Zambia, one nation, one people.